Good
Good
morning.
morning.
Morning, Jay.
Good morning, Sharon. Hope you're doing well. Good morning, everybody.
Morning.
Good morning.
Hello.
Good morning, everyone. My name is Rhonda Gullilan Lopez, and I am the Executive Director of the MCA SmackNum, New Mexico. And Carol Walker's Association and I will be co-hosting this morning. Due to the multiple presentations we have and the time that we have, we will not be doing self-introductions this morning. I am recording today, so if you need a copy of it, please feel free to contact me. I will put my email in the chat. Carol, would you like to go ahead and start, please?
That'd be great. Can y'all hear me?
Yes.
Okay. Today we brought in a group of speakers to talk about the past legislation concerning recreational cannabis. Each of the speakers were asked to limit their presentations to 20 minutes due to time restraints. And then also I'd like to ask the audience and attendees to send any questions that you have during the presentations through the chat link at the bottom of your Zoom page. So that way, we can keep each speaker on time and we can try to get your questions in at the Okay, our speakers today are going to be Jay Stimmel. I think most of you are familiar with him. He's with New Mexico OSHA. He's also always available to answer questions and help us out when we need a helping hand. Shannon Harmia, Seedcrest LLC. Hi, Shannon. She spoke at the ASSP conference and got great reviews. So I thought it would be a good idea to bring her to this group also. She's been around and she's done a lot of work and spent a lot of time in this industry, the cannabis industry. We also have Micah Doring, and he's a captain of New Mexico Department of Public Transportation that will give an enforcement idea of what might be coming down the pike for employers and employees as well. And finally, we have Aaron Gelb and Jordan Schwartz, who are lawyers with the safety group Marcel, Carey, and LLP. So each of the speakers will give us a different perspective. So I'm very happy to see so many people here because this is a very interesting topic, and I'm sure we're going to have lots of questions. So Rhonda is going to be the timekeeper, and then she will also do transitions. So I'm going to turn it over to her. Rhonda, you ready to go?
I'm ready. Jay, are you ready?
Yep. Let me share my slides.
Hold on one second. Let me give you permission. I was not aware. Apologies. Okay. And
I wanted to join Zoom about legalized marijuana.
I would respectfully ask everyone mute their mic if you're not speaking or presenting, please.
Okay, can everybody see my slides?
Yes.
Okay. Good morning, everybody. As as Carol said, I'm a compliance assistant specialist from New Mexico OSHA. I just want to give the titles of the different presentations. Mine is recreational cannabis in New Mexico, and we give an overview. Shan is just preparing New Mexico's employers for legalization. Micah is a captain in the state police, which is the New Mexico Department of Public Safety, and he's going to talk about the law enforcement perspective of cannabis impairment and tox results. And Jordan was not able to make it. He had something come up, so Aaron's going to give a presentation on New Mexico marijuana and drug testing update. Welcome to you all, everybody. It's a time of change. It's been a busy year. For the last 422 days, we've been in a pandemic. And it's nice to change topics, to get away from coronavirus and talk about cannabis instead. So can you please mute your microphones? And computers, we're getting some background noise. Okay, the Cannabis Act was signed on April 12th. So it's less than a month since it was signed by the governor of New Mexico. And it starts taking effect in a graded approach in 54 days from today. So this is basically one day of our preparation to implement the Cannabis Regulation Act. So this is the governor signed it on the 12th. It was passed in a special session of the legislature. It wasn't able to be completed in the regular normal session. They called a special session. They came to consensus. House Bill 2 was passed, and so it was signed by the governor. And so it's this is her press release when it was signed, when it started. Okay, so
Got it.
So it was signed. Then it takes effect. It's effective June 29th of this year. So as I said, we don't have much time. Time's getting short.
I went on Safari and said Cannabis Safety Coalition.
I'm sorry, somebody's coming in the background. So, okay. Here's the timeline. These are the things that are going to happen. So it's, they're going to create a regulatory advisory committee. It's going to be made up of all people from. We're going to have somebody from our department, from OSHA specifically. There's going to be people from other departments within the state. I'm not going to go into details, but they will form a committee that's going to kind of regulate things. One thing you don't see on here, you don't see OSHA. We do not have any regulations at this time specific to the cannabis industry. There's two areas that we're going to have regulations for. One for the actual cannabis industry itself, and then also for how other industries, the impact of people using cannabis and not using cannabis. So those will be implemented over those. Excuse me, it's been a long week, and I wish this would happen on Monday. Those will be implemented in a timely manner so that by April 1st of 2022, we will have something in place. We have a process we have to go to generate. The act says this is what shall happen, just like in 1970, the OSHA Act was created, and it took a year to be implemented and create regulations and standards. So we will do some of that. We'll be working on that for the next year, and to create our regulations. In the meanwhile, if things come up and there's things that need to be cited, it would be under our general duty clause. So anything that could lead to serious injury or death can be cited with the general industry clause if there's no current legislation. So can you see my mouse when it goes on the screen? So this is the big deadline. At the very bottom, the retail sales of commercial cannabis begins on April 1st, 2022. So it's April Fool's Day. I think they have a sense of humor, whoever came up with that date. But it's a graded implementation of this. And you can read this for yourself. My slides will be available for everybody after the presentation. Okay, so the organization within the state of New Mexico that has primacy for cannabis right now is the Regulation and Licensing Department, Cannabis Control Division. So this is, they're creating the whole process and the structure that will be implemented during as we implement the act. So we're starting from scratch. This is new. I know we're looking at, from our department, we're looking at other states that have programs existing. We don't want to reinvent the wheel. And I can't answer for the Cannabis Control Division, but I'm sure they're doing similar things. Let's use what's out there and save some time and effort. So just to let you know, this is what's going on. They will. There is one other change. It has Department of Health has run the medical cannabis program since it was initiated, but now that will be brought under the auspices of the Cannabis Control Division. So they will be responsible for recreational marijuana and medical marijuana. The registry itself will still be maintained by the Department of Health for people that meet the rules and requirements for the medical cannabis program. So if you go to the link on the bottom of the page, and this will be a clickable link when you get my slides, that is the home page for the Cannabis Control Division. This was a newly created division just for the implementation of the act. Okay. Linda Trujillo is a superintendent for the Regulations and Licensing Department. And, this is her comments. And I'll read for you, for those that can't see it. This is the right model for New Mexico because it creates a local, sustainable, and regulated industry while at the same time protecting our public health, road safety, and well-being of our youth. So it's an all-encompassing thing that's being looked at. It's not just we're going to sell this and that's it. It's to keep it away from the young, those less than 21 years old. Keep people under the influence. It's to keep them safe, the road and the general public health. So it's, and Mike will talk about the road, some of this road safety issues a little bit. So there's local jurisdictions. In a couple slides, I'll talk about what they have. Okay. So legislation has legalized cannabis. It's now legal in New Mexico, and there's rules and policy and more being developed, as I said. And local jurisdictions can create their own rules, but there's certain things they can't do. They can adopt the rules to limit the density of licenses and operating times of cannabis businesses. They can restrict access to the people who are 20 years of age or older, and require that they provide a consumption area that it be done there and not in the general public, and a distance away from schools and daycare centers, just like other use of other things, drugs that are not allowed to be done there. But there's certain things they cannot do. So you have this list. They can't, if you transporting it, they can't control that because it's federal, states requirements. The operation of a cannabis licensee. So I'll let you read through these. The daycare centers. But the most important one is that they can't prohibit adult New Mexicans from producing homegrown cannabis. So that's one of the things I'll talk about in a second here. But they have this local municipalities, the counties, cities, the towns can have certain rules, but they cannot inhibit homegrown cannabis. This is something that's thing. And homegrown or homemade means people growing at home. They're not going to sell it. It's for their own use. And so I want to get this clear. It's an important point. This is something that's going to impact industry fairly quickly. Okay. So for personal use, people can grow up to 6 mature cannabis plants and 6 immature cannabis plants per person. So it's limited to that. They can plant it, they can cultivate it, they can harvest, they can dry it, they can manufacture it, they can manufacture products from this homegrown stuff. That is legal. There is no registration or licensing required for home growers as of this time. That may be subject to change, but in this time, there's no limits. Okay. So someone can't manufacture cannabis extract, which is the edibles, is used in the edibles, without a license, except if you're a person that's producing and manufacturing for homegrown. So those 6 plants, 6 mature plants and 6 immature plants you can have. So it's not a crime if they do that. That's the exception. Okay. So basically, there's no time set in otherwise for this time frame for when this can be done. So that means it takes effect as of June 29th. People can start growing cannabis at home. They can, like I said, up to the 6 plants and 6 immature homegrown cannabis plants without any license requirements. So why have I overdone this portion of it so much? Because this is going to have an impact from the very start of the implementation of the Cannabis Regulation Act, because people will be able to use it at home, to create it at home. So people that have that are doing homegrown can use it, and then then we have the issue of the workplace. Aaron is going to talk about that, the regulations, the use and things like that. So some of those things, so he'll address those issues. Okay. So the Cannabis Act, these are employer protections. This is something that's very important to the people, this audience out here. There's a lot of employers, a lot of safety people. So unless there's some kind of agreement between employer and employee, you cannot. The act does not restrict an employer's ability to prohibit or take an adverse employment action against an employee for impairment or by or possession of or using of intoxicating substances at work or during work hours. This is our act. This is requirement. This is what your rights are as an employer, and so you can prohibit the use. You can take actions against people that don't abide by your rules for the possession, impairment by, or possession of. Micah will talk about the impairment issues. How the state police are going to look at it to give you an idea what's out there, what capabilities there are as far as testing and things. So, and Aaron will talk about the legal ramifications of this. So this does not prevent you from having zero tolerance. The other thing that will be addressed, there's a federal issue. It is still a federal crime to use cannabis. So, if you're working in a federal job site that has federal funding, so we have the national labs, we have the Air Force bases, we have DOT jobs. So, those are federal money. So, the second bullet is an important one. They can't require an employee to commit any act that would cause an employer to be non-compliant or in violation of federal laws or federal regulations. So, that's why I was talking about the federal issues. And, the concern is that there could be repercussions if you have people using impaired by marijuana on a job site. And so it's, concerned that you don't want to lose your job and the federal funding and the contract and be removed from the site. Okay. And then they can't, there can be a zero tolerance policy. You can have a zero tolerance policy for your employees in saying, you cannot be under the influence of marijuana on the job site. And once again, Micah and Aaron will kind of address those issues, some of those issues with the zero tolerance. You can discipline and terminate an employee on the basis of a positive drug test. And, what you're looking for in a positive drug test is the Delta-9 THCs, which are psychoactive cannabinoids. So, okay. Employee protections, it doesn't apply to the people subject to the Federal Railroad Labor Act. And if there are labor agreements, this cannot, interfere with those. It can't invalidate, diminish, or otherwise interfere with labor agreements. So those you have work with laborers. Okay. And adverse employment action means it's just telling what it does. What defines it. Okay. So I've tried to cut it short to allow time. I'd like Aaron to have a little more time. So we're waiting for questions for a little later, at the end. So all four people involved can answer your questions because some will cross lines. So once again, there are no OSHA regulations at this time, just standard regulations. We hope to have regulations in place that will address specifically the cannabis industry and also address people, that are using cannabis while they're on the work sites. And so that'll be a while yet. We have almost a year to get those in place before the normal users. The home users will, if there's incidents, like I said, we'll have to use the general duty clause. So thank you all. This is my contact information. Questions will be, wait unless somebody has a very pertinent question right now. I would prefer that you wait till the end of the presentations. Okay. Well, thank you all for your time. I appreciate it. I'd like to thank our other speakers. This was done at very short notice because we wanted to get things rolling. We want to be proactive. We want to try to be consistent across all our industries in the state of New Mexico, especially in the construction industry. So when people go from one job site to another, the rules are consistent. One job site is 0 tolerance. And the next one, it says, yeah, you can smoke it, but you got to go get off the property, the construction property. We want consistency to make it fair to the workers. And so, and proactive so we can get on top of things, determine what actions we're going to take, and all work together to have something that's functional for all of us and works for all of us, and is compliant with the rules and regulations and standards that exist and will be created as part of this act. Thank you all. Have a good day and be safe.
Thank you, Jay. Shannon Jaramillo is next on our list. Shannon, are you ready?
I am ready, and I have slides as well.
Let's see if I can bring those up. Are you going to try to do it first, or?
I'm looking at the process here, and yes, I can do that myself. Thank you very much. Let's see here. Awesome. Can everybody see these slides? Yes? Okay. Okay, cool. Rhonda, you can see them?
Yes, I can. Thank you.
Okay, awesome. Thank you so much. Hi, everybody. And my name's Shannon Jaramillo. First, I want to thank Jay. That was a great presentation. Some of our presentation overlaps, I noticed. So I will be brief as well. And I am an industry activist, and I'm also the founder and CEO of Seedcrest. We are a workforce solution and educational curricula licensing software. You may start to hear our name as we are the group partnered with Northern New Mexico College, putting on that college accredited program called the Cannabis Establishment Tech course. So we're doing some pretty innovative stuff in New Mexico, and I'm from here, and I've been active in the cannabis industry, particularly over safety training and compliance training now for almost 5 years. So today I want to talk to you briefly about preparing New Mexico's employers for legalization. Okay. So some of the points or objectives that I will touch on today, number one, the Cannabis Regulation Act. And if you can please mute yourselves, thank you very much. That's very helpful. So we'll talk about the Cannabis Regulation Act, House Bill 2, just briefly. It looks like Jay really covered that. Then we'll go on to review some of the important federal laws that employers are up against. And then we'll review the New Mexico Medical Cannabis Program, and I'll go on to make suggestions about how to address or start with company policies. Mostly what my job is here, I believe, is to help you folks to interpret the laws and the regulations, as well as to give you resources and a starting point so that you can start to make some or gain some clarity around what's taking place in our state and how it might affect your business. One thing I do want to say before I really go into this is on the heels of what Jay said about OSHA. OSHA in Colorado has had a program, or at least a manual, out since about 2016, I want to say. And so if you're OSHA or New Mexico Environment Department professionals in this call, this is me calling out to you folks to say that it's long overdue for us to gain some traction around how we're going to keep the cannabis industry workforce safe, let alone the other employees in our other industries here. And so I'm asking that if you want to talk about this or work together on this, I would be so happy to help and to show you some resources upon some of the research that we've done in other states that are actively involved, where federal funds kind of are the barrier right now. And so I just want to mention that because that's a challenge, and all of us in this call are promoting safety, I'm hoping. And so I just want to say that that's something that's needed, and that the workforce in the cannabis industry has really been operating at a deficit without this oversight for quite some time. With that said, I'll go ahead and go into things. So House Bill 2, Jay went over that pretty clearly, and I think verbatim in some cases. So you folks take a look at House Bill 2 so that you can really start to gain clarity around how that affects your businesses, particularly, what does it look like for your employees to have access, and what are their rights? And how does that work within your wellness programs, right? I want to get you guys to start thinking about why people might be already using cannabis in this presentation, as well as how your employees might choose to use cannabis on off hours, and how employers, can gain pace with education to help them to make some non-discriminatory decisions and practices around these new laws. With that said, you can consider that New Mexico is now regulating and taxing cannabis just like alcohol. But now we're taxing it like alcohol, but we're saying that we are allowing for a medical cannabis program. So they sort of flipped the script on us with House Bill 2. When we enacted House Bill 2, we already had a 14-year-old medical cannabis program and a large cannabis consumer base who consume based on medical conditions. And I'll get into that here. But now, as Jay pointed out, regulations and licensing department are overseeing the Cannabis Control Division and the Regulatory Advisory Committee. And Linda Trujillo, Superintendent Linda Trujillo, has been tasked with getting all of this on going and writing the regulations and organizing around this effort. Okay. With that said, there's a lot of new information coming out every single day about how this will impact New Mexico. We did see that they really use the 11,000 jobs to push this through, in an effort to stimulate our economy. And so right now there are 3,000 jobs in the workforce currently working with patients in the field. So, when we really look at the data, we're looking at about 15,000 jobs overall building, but we still have some capacity building to do around that effort. And so how do we do that, right? And how do we keep employers safe? Well, as you go through the bill, there's a lot of language that I'd like you to consider. And starting with the definitions, as you start to dissect a few of these bills to see how they overlap with your company policies, your company funding, the federal laws that you abide by, Section 34, as pointed out by Jay, gives you all of the employer protections, but really dissecting that language and seeing how it crosses over with any contracts that you have with your employees now, and how that crosses over with your policies and anything having to do with safety sensitive workers. And I'm not going to go through this verbatim, but I just want to point out these sections again alongside Jay, so that you have, a good starting point. Basically, you can find this information at nmlegis.gov. That is where you can find all of our bills. And then there's a few other places you can track bills in different states, particularly cannabis bills. So I'll point some of that out to you. As Jay pointed out, the Cannabis Control Division, housed under the New Mexico Regulations and Licensing Department, will be your best resource at this point. I can say that this website is changing almost every day. And so I do check it out a couple times a week just so that I can stay current. Excuse me. And I suggest that you do as well. If you're looking about business licensing, you go to the tab up top that says adult use and pull down that drop down menu, and there's a lot of good information in there. As far as the timeline goes, it's a pretty clear-cut timeline, but at the same time, the folks in regulations and licensing are expressing that they're having to move pretty much overnight, and as well as they're on a learning curve as well, right? And so I think, you know, overall in my experience here in New Mexico, I've seen legislators who are tasked with this type of promulgation of law per our New Mexico statutes annotated, per different regulations and different cannabis acts. We have to have patience because they too are on learning curves and we're all learning together. So the more that we can have these discussions, the better. This is actually a copy paste from that site and has, you know, some of the information around what the CRA, or the Cannabis Regulation Act, that's, you know, an acronym that you should learn because that's how they'll start to talk, is in these cannabis acronyms, right? And so CRA being effective June 29th. And basically, what is that going to do? Create the licensing, taxing, and enforcement of regulatory structure. And then again, what does that do to the current law, the Lynn and Aaron Compassionate Use Act? So right now, I find that legislators are sitting there really trying to figure out how they overlap with a highlighter and figuring out, okay, what parts of this does this affect our cannabis program, our medical cannabis program, and how are we going to really move forward in putting together the processes? And so we're in that beginning stage of or phase, as other states around us have done before and gotten through, but we're still in that beginning phase where it's a little bit vague and we don't have the regulations quite yet. All we have is the statute, right? And that very well could change a little bit as well here in an upcoming session. And so we want to make sure that you're following all of, you know, the activity so that you can have the most current information. Here is another I guess, overview of the timeline, and my slide deck will also be made available for everybody. I just sent it over to Rhonda, and I'm happy to make it available myself. I'll give you my contact information after this. But like I said, we're still interpreting what this all means. You know, putting together a cannabis regulatory advisory committee allows the Cannabis Control Division to have folks in the community who are active or who have, you know, more experience in this field to help them out. But I know they've just gone through the taking in of applications. And so we're anticipating that it'll be, you know, at least a month or so before they iron that out and really start to let us know who's on that committee, right? And so make sure that you're updating yourself on stuff like this so that then you can get to know who's overseeing what. And it might be your best bet is to find these experts like me, or, you know, patient experts or banking experts, financial, you know, safety experts out there like Jay, who can help to start grasping what's happening, right, and how it affects your company. Now, I pulled this information from a site that I want to promote here. The Marijuana Policy Project is a great third-party resource and a cannabis bill tracker. Notice on the left-hand side of my screen, we do have DUI changes that we need to be considering, and hopefully we'll learn more about this even in the call. A lot of people are most concerned about, you know, road safety. And we are historically a state that has a high DUI rate, and it's something that we've you know, been battling for quite some time in our state. And so we don't want to add insult to injury. How do we combat that? How do we, you know, how do we issue fair and non-discriminatory practices over the consumption of marijuana or cannabis in our state without creating, you know, or going down a path that we don't want to go down, right? And so New Mexico House Bill 4 was not adopted, but it's showing as failed. But it's something that I want you folks to be looking after, because it could very well be that Representative Bill Ram takes it back to you know, the legislature, and we see it reappear. I know it's something that we'll have to you know, work around at this moment. And so I'm encouraging state and public safety officers to gain as much education as they can around how the endocannabinoid system and cannabis and cannabinoids and the compounds in the cannabis plant react with your body in real time versus how do they react with your body, 2 or 3 days later, so that we can understand it from a medical and scientific perspective, especially until we have that magic device that folks can just blow into and we can tell that maybe they've consumed and broken the law, right? And so that's one bill that I'd like you to look at. And then notice on the right-hand side, there are several other bills to review. Senate Bill 2 gave us the expungement of certain criminal records. And so we are going to see the state go through the process of expunging marijuana crimes soon. And that should be its own effort that will, lead into our, businesses, into our hiring practices, and something that we want to get ahead of. NM House Bill 2, General Appropriation Act, will start to, indicate how they are going to appropriate funds. And then House Bill 183, NMHB 183, let's look at how much one can possess and at what point are we criminalized, right? And so you want to just familiarize yourself on behalf of your employees. One day you might get a call saying somebody, broke the law, they had too much in their possession, or maybe they had just the right amount, but the police didn't know what to do and they're in jail now and they've got to, go through the court systems and figure out this vague kind of learning curve together with everybody. So you want to be ahead of that as an employer in our state right now. So when I look at what we're doing in our state, it's pretty simple. It's progressive and disruptive cannabis policy. This is happening all over the country right now. We're just a part of it right now. And you're starting to see some legislators, kind of say, I told you so. I knew this was going to be a disaster, or some of the legislators saying, this is awesome, let's get behind this. And so as these folks go through their own, campaigns, you're going to start to see how their constituents view them, and they'll start to talk about it from different platforms. But make no mistake, we ourselves can do our own research, and I'm encouraging that you do. And, as a company with HR practices, employer that has to abide by different laws, it's okay to start thinking about the wellness of our employees and thinking of it from a different perspective. We have stigma perspective kind of bred into us now. And so thinking about it, apart from stigma and looking at it medically and scientifically, how can you, how will adult use affect your business, right? How will it really affect your business? And then could some of your employees already be cannabis patients? I want to challenge you to think about that. Or would it allow a different quality of life for your workforce if your employees are allowed to ingest the cannabis plant for medical or recreational use, right? Is there a stigma around cannabis in your professional or personal life? And what is there to learn? Can we help to unpack some of that with you at Seedcrest, right? What is the difference between the medical cannabis patient and a recreational cannabis or adult use consumer, right? Do you already know people who are choosing to imbibe with cannabis instead of alcohol, for example? And, let's think about, will adult use cannabis actually give New Mexicans an economic boost? And how can we contribute positively to that? And so these are some of the challenging questions that I'm going to put on the table for us today to walk away from this thinking about. And then, as we move, reviewing federal cannabis is going to be important. Just going straight to the DEA website, they've got a DEA marijuana fact sheet up. And it actually, it gives you some really conflicting information. It says we're Schedule 1, marijuana's, under the Controlled Substances Act, is a high potential for abuse and has no current medical accepted use in the United States and has a lack of accepted safety unless under medical supervision. Well, then they go on to say, oh, and by the way, we don't have any overdoses and it's not really that bad. And so make sure that you're reading some of these at the federal level so that you can see where this thing is headed. Even federal government is starting to put out info that is suggesting that they are looking at things a little bit differently. One second here. And I'm getting close here. I don't want to take up anybody else's time. So I have a feeling that everybody in this meeting has touched on the Drug-Free Workplace Act. And if you have not, I'll just mention it here so that you can make sure that you pull it up and take a look at, how that overlaps with cannabis laws and any of the funding that you get as federal employers. For example, we're already hearing about federal government putting barriers into funding incentives or initiatives in our state. And that's very common. You'll see state initiatives try to pick up and federal government kind of stifle them. And so making sure that you understand that part of progressive and disruptive cannabis policy. And then what is a safety sensitive position? So we have people that may be working for us that aren't safety sensitive workers. So do all your employees, are they all responsible for their own or the public's safety? Right? Or are they working in administrative roles, and should it be their right to consume? Thinking about these and how they work, and then talking to your legal teams to make sure that you really are covered is going to be key as an employer. And then I just want to put out there that the New Mexico medical cannabis patients are employees too. And we've got over 115,000 of us, I'm a patient as well, working productively in the community. And so why would one of your employee be using cannabis medically? Well, there are 28 reasons at this time that suggest that they can, is why, for quality of life. And so take a look at the Department of Health and how they work around patients and patient rights in the Lynn Aaron Compassionate Use Act. We have anyone from, an elderly, end of life, long-term care individual taking cannabis to a Vietnam veteran or PTSD war hero, all the way to farmers who are farming it actively in our state, hemp and cannabis. And then you can see there by the little map in the left-hand corner that we have dispensaries placed all over the state to help people to ensure that they can access their own adequate supply of cannabis. The Lynn and Aaron Compassionate Use Act was passed in 2007, and that's something that I'd like to challenge employers to take a look at and to try to understand, because it allows the beneficial use of medical cannabis for alleviating symptoms caused by debilitating medical conditions. And so again, in realizing, why would my employee be needing cannabis? If Linda comes in and she's chosen to take an opiate for her pain, but still gets her work done, then that is something that we've worked around, because that opiate, if not prescribed, is an illegal substance. But if Linda chooses then to take a cannabis or marijuana tincture under her tongue, and she still gets her work done, what is that, how is that viewed at your place of employment, right? So just thinking about the real cases that are out there. And then the final suggestions I have are to review and update current company policies, and to consider posting signage on site per the Drug-Free Workplace Act, because as Jay noted, there are no stifling of current company policies just because we have access to recreational cannabis. So want to empower you folks to make sure that you have what you need up around your safety sensitive workforce as well. So make sure you're reviewing, interviewing, onboarding processes, handbooks, and the basics of your company policy. I won't go through this. I know that we might be talking about it moving forward, but there are some new information around saliva testing for cannabis to help identify impaired drivers. That's all new on the market, and they are still looking at how they are going to test in real time. So if you're an employer who does drug tests, you want to stay up to date on stuff like this. Okay, and I think I'm coming to the end here. Yes, here's my information, and thank you so much for letting me. I know I went over time, but I do have a lot of references. I didn't. Okay, talk pretty fast. Thanks, Rhonda. I have a lot of references that I can provide you, and I look forward to your questions after all of the speakers.
Perfect. You had 12 seconds.
Awesome.
So our next speaker is Micah. Micah, are you ready to go?
I am ready to go.
All right, perfect. Well, welcome, Micah. I'll turn it over to you.
Okay, and I don't have any slides, so you're going to be stuck with looking at my ugly mug for a few minutes here. If you don't like that, just flip your screen around. A lot of people would think, hey, wait a second, this guy's a captain with the New Mexico State Police, and we're going to see the opposite perspective, because he is obviously coming on board from the perspective that last lady, woohoo, I mean, wow, Shannon, she is off the rails. She has the title activist, crying out loud. So, and we all know that activists and cops can't get along. Well, I'm here to tell you, I may surprise you, but a lot of what she's just said is in my notes to say. And I'm going to key on several of those little things that she said, starting with what she ended with. I'll just do that because that's the easiest segue. As far as the testing purposes for THC, a lot of people were mentioning the Delta 9 THC. That's what actually comes off the plant. Once it gets into the body, just like any other substance, from alcohol to cocaine to heroin to that double bacon cheeseburger you're fixing to have for lunch, once it gets into your body, the body metabolizes it. That's just a big fancy word phrase for saying it changes it into something the body can use. With Delta 9 THC, one of the first metabolites, and by the way, there's like 50 bajillion different chemicals within the marijuana plant itself. We focus on the Delta 9 THC, especially as law enforcement, because that's the main impairing substance. And if you've ever gone to a dispensary or know anything about the cannabis industry whatsoever, there are different levels of THC in the marijuana or cannabis products that are out there. And we'll touch on that just a little bit as well. But the Delta 9 THC actually metabolizes into, there's big long chemical names. We reduce it to the hydroxy THC. And once the body changes it into that, the body can use it a little bit differently than just the straight Delta 9. Unfortunately, the hydroxy THC is also a potentially impairing substance within the body. The body then takes that, metabolizes it one more time, and turns it into carboxy THC. That's what's excreted from the body typically. The carboxy THC is not impairing. You're not going to have the high. So as employers, when you go out and get tests, whether they're urine tests or blood tests, whatever lab you're using, as saliva tests start coming into play, that's going to be the next big thing enforcement wise, because it's going to be faster, easier, minimally invasive. But we have to get it to a scientific level that it's reliable, it's accurate, it meets the legal requirements to charge somebody criminally. Because you think about it, charging somebody criminally, taking away their freedom, that's a big deal to law enforcement officers. Yeah, I'll admit it can be a lot of fun putting on the handcuffs to some people who desperately deserve it. But one of the biggest fears in my 21-year career is putting the handcuffs on somebody who didn't deserve it. Okay, some of these tests are going to be able to draw the line between the two of those things. If the tests you're testing for the metabolites, which typically, let's start with a urine test. Urine is being excreted from the body. It's not going to look the same there as it did going into the body. A urine test is looking for a metabolite, but is it looking for the hydroxy THC or is it looking for the carboxy THC? The carboxy THC, you can get hours and even days after the high is gone, after the impairment is long gone. That person is showing no signs of impairment. So you've got to know, number one, what is your policy going to be? If it's zero tolerance, it's zero tolerance. But is it zero tolerance impairment or thou shalt not use ever in your life? There's two different standards for zero tolerance right there. So that's going to be up to your company, up to your policies, so on and so forth. But if you're going to focus on impairment, like we do as law enforcement officers, you've got to know what your test is testing for. Whether it's the actual Delta 9 THC disappears in the body very quickly, 30 to 90 minutes. The hydroxy THC, in my experience, 2 to 4 hours. and the impairment from a single dose of a cannabinoid is gone. And then you also have to talk about the tolerance of the user. And I'm sure, I don't know, I can't see Shannon right now. She may or may not be nodding her head. But somebody who uses a given level, let's talk about the medical cannabis folks, if they use a specific level at specific times throughout the day and it just maintains, it's really not a whole lot different than somebody on an anti-anxiety medication. The first few times or few days they're using, they may be impaired, and then 2 weeks later, at that same exact level, that person is not impaired anymore. Okay. That's why, as law enforcement officers, and where I get my level of expertise, I'm known as a drug recognition expert. And a lot of people think that name, oh, well, I can put out 25 drugs on the counter and you can tell me each one. No, that's not what we do. I can find drugs in somebody's blood faster than I can find it in the trunk of their car. That's just me. We run them through a series of tests. We take from clinical signs, from measuring pupils, judging their reaction to light, blood pressure, pulse rates, and then we run them through a series of psychophysical tests known as standard field sobriety tests. And a lot of people say, well, those are for alcohol. Well, they're for impairment. Doesn't matter the substance, really. I also instruct in this and have been an instructor for about 12 years in this particular section. We focus on the impairment. If they're impaired, they get booked. If they're driving, if they're the passenger, we don't care. Gack out, knock yourself out. But the other thing is, if they're not impaired, the substance could be found in their blood. There are a number of people that I've evaluated that have not gone to jail that I know for positive fact that if I took their blood, they would be positive for a substance of some sort. But at that particular moment in time that I am testing them, they are not impaired. The law says you can't drive while you're impaired by a substance, any substance. It doesn't make any difference whatsoever. So impairment is the key. Know what your test is testing for, whether it's a metabolite or the actual drug itself in the body. This goes for cocaine, heroin, meth, any of these. A lot of people will draw a distinction between what is medical marijuana as opposed to recreational or illicit marijuana. What's the difference between those three? It's legal status only. Once it gets in your body, it acts exactly the same. Delta 9 THC is Delta 9 THC. The body is going to deal with it regardless. Okay, so there's no difference there. What kind of impairment would you be able to see at very, very low doses? You're not going to see any. It may surprise you coming from a law enforcement officer, but at very, very low doses of THC, you're not going to see impairment. Once that dose level rises, even in tolerant users are going to require a higher dose level, not nearly as predictably as alcohol, though. But once the levels go up, you're going to start seeing things like short-term memory issues. They're going to forget, from our perspective, they're going to forget some really essential things. One, things like maintaining their lane, maintaining proper speed. They're going to forget to put on their seat belt or other safety devices. They're going to get what to do at stop signs, like stop. You gotta evaluate those things. We look at the impairment. That's what you as employers ought to be focused on, especially in like construction industries where you've got power tools, you've got equipment, heavy equipment, you've got cranes, weight overhead, things of that nature that when used improperly can injure or kill. We've got to keep our workforce safe at work. So impairment is that line. Do you want to allow weekend use and not during the workday? That's going to be all up to you. Typically, for the non-chronic user, 2 to 4 hours, the high is gone, the impairment's gone, and you'd never know that they were a user unless they told you. Okay. So you've got to keep that in mind when you're writing your policies. I'll let the policy folks with the law degrees go ahead and take over from there. A lot of people, one more thing with the difference between alcohol and marijuana. Alcohol is a little more predictable at given levels across a broader spectrum of human beings. We're all biological samples, so it makes a difference. If somebody is a chronic alcoholic, they will show fewer signs of impairment outwardly, like they'll be able to still walk straight at a 1.0 or a 1.2, whereas someone like myself who doesn't drink any alcohol at all, you throw 2 beers into me, I'm not going to be anywhere near the legal limit, but I'll be sloppy drunk. Okay. Marijuana is somewhat that way, but it's not nearly as predictable. And that's why me personally, and under the auspice of the Drug Recognition Expert Program, not the New Mexico State Police, please make that distinction right now. Bill Ream's legislation that failed this last time, it's failed like 3 or 4 times in a row now. It's wanting to set a per se limit. And usually the 2 numbers that I hear are 3 nanograms and 5 nanograms for blood concentration of delta-9 THC in order to show this person must be impaired. We as drug recognition experts don't agree with that at all, because there are some people who can be at 6, 7, 8 nanograms and not showing any signs of impairment, and there can be others at 2 and 3 nanograms who do show signs of impairment. We go off the impairment and then link it to the toxicology and let them do that kind of testimony. So I'll go ahead and shut my pie trap right now, because I really don't see anything else that I need to hit. A lot of everything else that was on my notes has already been touched on by other people. One little parting comment that I noticed, I starred, CBD, that's not impairing. So if somebody's eating some CBD gummy lunch, just because it comes from a similar plant with the hemp oil and all of that, CBD is another one of those chemicals that can be found in marijuana. It's also found in the hemp. It's non-impairing substance, so don't sweat it. Don't jam people up over it. And I'll look in the chat box for any questions. And then I guess we have a question and answer session a little bit later. I'll stick around for that. Rhonda, it's all back to you.
Micah, thank you so much. I appreciate that. If I remember hearing Jay correctly at the beginning, Aaron is unable to join us today. However, Jordan is here. Is that correct?
It's actually reversed. This is Aaron. I'm here.
I apologize.
That's okay.
Sorry. Okay, Aaron, well, thank you and welcome.
Thank you. So let me share my screen so I can get the presentation up for you all. Can you all see that?
Yes.
Okay, great. All right, so we'll just jump right in. So again, my name is Aaron Galb. I'll do a very brief introduction, self-introduction. I know people don't tune in to these programs to hear us talk about our backgrounds. Suffice to say, I'm an OSHA lawyer. I've been a management side OSHA and employment lawyer for the past 25 years. Attended law school at University of Texas in Austin, made my way up to Chicago, and I devote the bulk of my practice to representing employers with respect to federal OSHA inspections and state plan states such as New Mexico, dealing with New Mexico OSHA, folks like Jay, as well as a number of most other state plan states throughout the country, California, Washington, Oregon, and throughout the country. Our firm is primarily an OSHA boutique firm with about 17 OSHA lawyers spread across the country. So we deal with all manner of incidents, many of which, or at least unfortunately, a certain number of which are related to impairment. The instances where people do inexplicable things, sometimes just due to poor judgment, other times due to, as Micah said, I mean, not having a memory, not having a recall about what they should be doing at work, reaching into a piece of equipment that they know, if not impaired, would know that is dangerous, and yet they do it anyway. So one of the areas that often crosses over into the OSHA world, obviously, is drug testing. OSHA stuck its toe in the pool, if you will, a number of years ago during the Obama Biden administration, issuing a rule, which I'll talk about a little bit later, addressing the ability of employers to kind of conduct comprehensive drug testing, and the agency's belief at the time that may be done for retaliatory or discriminatory purposes. But to set the stage, so what I wanted to cover today is begin with kind of an overview of federal legislation and rulemaking in this area, or a lack thereof. Then talk about some of the state issues. I apologize for my alarm. I thought I shut that off, so it'll shut off in a second. Then we'll talk about, as I said, the drug testing restrictions that OSHA put forth a number of years ago. We'll focus then on the Americans with Disabilities Act, the federal ADA law, and how that deals with drug testing. And then last but not least, we'll dig into the laws in New Mexico and how they impact drug testing, both with recreational marijuana as well as now the legalized, or medical marijuana, as well as the legalized recreational use. So to set the stage, the questions that our clients often come to us with regarding drug testing is, what can we do with respect to testing current employees? There's all manner of different types of testing, different phases in the employment relationship, incidents that may prompt testing. Can we do that legally? What can we do with respect to testing applicants, if at all? And if we are going to do that testing, how do we ensure that we as an organization don't run afoul of those laws? And so what are the legal concerns that are out there? First and foremost, and I think the issue that most employers look at initially is just is there a federal law out there? What are the state laws that apply? Does my state restrict random testing? Does it restrict pre-employment testing or post-incident testing? But there are a number of other considerations that come into play, including defamation. If you do test somebody and they test positive, who do you share? Who can you safely share that information with? Typically need to restrict that to those with the need to know. Anytime, and this applies also to sort of any adverse action that's taken with respect to employees. It's one of the reasons why we always advise employers to not share information. And I think most employers, if someone comes to you and says, I need to know what happened to this person, were they fired? What did you do to that person? Most employers are going to say, we don't discuss those personnel decisions with everybody outside of this certain group. And so that's primarily because there's a concern. If you say the wrong thing to the wrong person, you open yourself up to potential liability for defamation claims. There's also the potential risk for invasion of privacy claims, and that often deals with the manner in which you're conducting the test. If somebody, in terms of the privacy, I mean, particularly if you're using urinalysis or those types of methods. And even at a very basic level, discrimination claims, how you administer your drug testing program. There's often some competing considerations. And again, when I talk about the OSHA rule, OSHA has taken a dim view of blanket drug testing or testing everybody. They think that has a deterrent effect on people coming forward to report injuries or incidents. So OSHA doesn't like across the board testing. Well, what's the safest way to avoid a discrimination claim? It's to test everybody. So if you're investing your managers with discretion to decide who do I test or who do I send for a test, then you have the potential that those managers are only going to test members of a certain gender or a certain racial or ethnic group, older employees, younger, whatever it may be. So then you have the risk that you're going to see claims that, well, they're only testing this group, and that's discrimination. So you need to, when you have a drug testing program, that's one of the things you look at is and track, who are we testing, and are we testing in a non-discriminatory manner. So digging a little bit deeper into drug testing and some of the employment laws that are implicated. I mentioned earlier, there's obviously the federal government that sits over everything, but in this case, that there is no overarching federal drug testing law. There are laws that deal with drug testing, but there is nothing that the federal government has issued. If you think about in the employment law context, you've got Title VII. So this is the law that prohibits race, sex, religious discrimination. That essentially sets the law of the land. So even if, while states are free to pass their own anti-discrimination acts, there is still this federal law that is out there that is available to anybody to bring a claim in, regardless of the state in which you're located. So there is no federal drug testing law that sets standards or places limits on the types of drug testing that employers may do as a general basis. So what does Uncle Sam say? The law that is out there, the Drug-Free Workplace Act, it applies to contractors. As I said, it does not require drug testing. It does require the development and adoption, implementation of a drug-free policy and a program. As you all know, and I think other speakers have covered, that marijuana remains a Schedule I drug under the Federal Controlled Substance Act. I certainly, if that's one law or one of the laws that we will continue to keep an eye on, because I think, we can see obviously momentum is building among the states to legalize recreational marijuana. Certainly even greater momentum with respect to medical marijuana. So I wouldn't be surprised to see that change at some point in the future, but that for now, that remains the law of the land. And where testing is required under federal law are those positions that are covered by the Department of Transportation, as well as certain public safety positions with the Department of Defense. I'm sure those of you that are listening in or watching it know if you're covered under DOT regs and all the different regulations. I mean, it's a very complicated, very regulated area that deals with drug testing for DOT covered employees. So marijuana is prohibited. Its use is prohibited under the DOT regs and by drivers and other covered employees. So there is pre-employment testing under these regs, post-accident reasonable suspicion testing, as well as random testing. And in the event that someone is returning to duty after a restriction or something along those lines, there's also that type of testing that is required. Additional obligations that are imposed by the DOT regs include the requirement that you as an employer obtain drug and alcohol testing information from an applicant's prior employer over the past 2 years. And in addition, there are specific regulations about how the testing is done, the use of medical review officers, and a whole host of things. And it's so specific and so involved that there are lawyers who specialize specifically in DOT regulations. I think there are even law firms that focus on that as well. because there is so much involved in terms of standing up and implementing and enforcing a compliant DOT drug testing policy. So I mainly wanted to flag that for everyone. Again, I assume most of you that have that are aware of it, but for those of you that are questioning it, I'm happy to discuss that offline, but could create an entire program out of that alone. Another element that is sometimes overlooked is the labor relations implications of drug testing, particularly if you're looking to stand up a drug testing regimen where you haven't already had one and you are a unionized workforce. I mean, this is something that you are going to have to bargain with the union. I've yet to see an instance where an employer has attempted to adopt or change its drug testing program in a unionized setting where that didn't raise, a significant amount of significant ruckus with the union. That's something obviously that the union and its members are going to care about, particularly I think in states where there is legalized recreational marijuana. I assume the union is going to hear from its members if its members enjoy using marijuana recreationally, that they don't want that to implicate or affect their employment prospects, their ability to remain employed. Obviously, the disciplinary implications that are associated with drug testing are going to be directly tied into the collective bargaining agreement and all the various rights and benefits that the union members. So that's the key there again is if you have a union, need to think about and approach the union to negotiate over the subject. At the same time, if you're not unionized, but you're concerned, there are whispers of organizing, or you think that you're a target for organizing. From a practical standpoint, it's really not a legal consideration, but from a practical standpoint, you should take into account, if we adopt this drug testing regimen, is that something that might prompt our employees to seek union organization? If they feel that this is a big deal for your workforce, is that something that might be kind of the straw that breaks the camel's back and pushes folks to try to get a union into the workplace if that's something that you're opposed to? So in terms of then, we've talked a little bit about the federal arena, the general lack of any oversight or baselines as far as drug testing laws. So that really, what that means is that it falls to the states. The way we look at it is essentially you start from the premise that employers generally have a right to test for drugs unless restricted. And there are, as I've said, different states that take different approaches. But this is an area of the law where you can have significantly different obligations if you have locations in different states. And it can be a rather cumbersome and complicated process. So you obviously this is a webinar about New Mexico, and so you have New Mexico operations, and I'll talk about the laws there. But if you then have operations in California, you're going to have different obligations with respect to your testing there that are going to be very different than, say, in Texas or other jurisdictions across the country. Some of the things that we see, reasonable suspicion is one type of testing where the laws can vary quite significantly. Random as well. A lot of states, or a number of states, I should say, restrict or even prohibit random testing. Obviously, the thought being there, from a fairness standpoint, at least in those states that have these restrictions, is it's one thing. Yes, we want you want to test somebody before they apply to work for you. Fine. You want to test somebody because they've had an accident or they appear to be under the influence. Fine. But if you're going, to take that next step and test people randomly, who have done nothing wrong, who don't impaired, who are using them in a responsible way, that may be one step too far for some of those states. So that is a restriction that we see quite often. Other states require adoption of written testing programs or policies. Other states mandate certain methods for handling the specimens or using the results. So the good news for those of you who are listening, that New Mexico is an open state, which means that from a testing standpoint, there are no restrictions that are imposed by the state of New Mexico on an employer's ability to test. That said, is that something that could change? Here in Illinois, we heard this said the other day, and I've been saying it for a while. We're not California, but the state legislature seems to be trying to get us a lot closer to California as far as regulating employers. And so we've passed recently a background check law that we used to restrict the use of arrest records. Now we're restricting the use of conviction records. I'm expecting at some point we may see greater restrictions or legislation dealing with drug testing here in Illinois. So as the right or the ability to use substances increases, I think that is something that kind of trails behind, which is if we're going to extend or allow individuals, and then by that factor employees, to use certain substances, we may now decide to restrict an employer's ability to test for them, which is something that's happened here in Illinois as well. But for now, know that you do have essentially an unfettered ability to test employees in New Mexico. There are no restrictions on random testing or pre-employment testing, post-accident testing. It's not to say that there aren't things that you need to consider, such as in the context of OSHA regulation, but I'll talk about that in a second. So where OSHA stepped into the fray here was when the agency issued, and it was really in the context, and I think it caught a lot of us on the OSHA bar somewhat by surprise, when OSHA issued its rule to improve the tracking of workplace injuries and illnesses. This was the rule that was really focused on ensuring that the employees understood their ability to report injuries and illnesses, and that employers were not discriminating or retaliating against those individuals who did so, who came forward and said, I hurt my shoulder, I injured my foot, or I've developed this medical condition due to some exposure in the workplace. That there were employers that were retaliating or discriminating against employees for doing that. And so OSHA issued this new rule, and then as part of that, really began focusing, or as part of that included a focus on drug testing. And a lot of this, as I said before, talking about the unions, our understanding and discussions with OSHA and attending a number of public meetings about this, was that part of this was driven by the labor unions. There, in particular, I think it was Unite Here, and perhaps SEIU as well. But the concern from the employee community was that drug testing could be used to dissuade employees from reporting these injuries, because they knew if you had this blanket rule, meaning everybody who reports an injury gets tested, that people are going, someone who's legally using or I should say using marijuana, but it's not impairing them. They're the person that's using it on a Friday, and they're not impaired by the time they come to work on Monday. But they then injure themselves on Tuesday, that they know that they will still test positive for marijuana, so they don't report that injury. And so there's this belief or argument that post-injury drug testing essentially is used almost as a form of discipline, or as a way to then discipline the employee, not because they use drugs, because they weren't impaired, but because they reported this injury. So you see situations like I had one case, and it was a surprising one. I think it was in Indiana, where it was a younger employee, maybe a 19 or 20-year-old individual, who reported a repetitive stress and strain injury dealing with pushing some sort of a cart in a facility, something that they did on a daily basis. And she initially raised that, and then a few weeks later, she went to a doctor for treatment for this repetitive stress injury. And for this employer, the trigger as to when an employee is sent for a drug test is going to a doctor. And so she then is tested. She tests positive for marijuana, and disciplinary process begins. and whether she had a lawyer in the family or someone who was familiar with the OSHA regs, the company gets a well-drafted letter warning them that their actions are potentially in violation of these OSHA guidelines. Not something I see often. Many people are not aware of this, but that would be one thing that I had warn employers about is if you are doing blanket post-injury drug testing, that's something that OSHA will likely take issue with. This OSHA rule does not bear on or any way implicate pre-employment testing, random testing. So as I said before, random testing is something that some states frown upon. OSHA does not take issue with random testing. If you're doing the testing, as I said before, to comply with mandatory DOT tests, OSHA doesn't take issue with that. If the testing is required as part of your workers' compensation protocols, that's okay. And so then the one area, the primary focus for OSHA is when you're conducting post-incident or post-accident testing, what they're looking for is the employer's ability to connect the determination to test with some likelihood that intoxication or being under the influence contributed to the accident. OSHA gave as an example, if an employee is stung by a bee and they have an allergic reaction and they're hospitalized, stung by a bee in the performance of their job, that you would not test that person because substance abuse presumably did not contribute to them being stung by a bee. Being a management side lawyer, I could come up with reasons I think where that might actually be the case, but you would look at it, and I use this as an example. I represent a number of hotels and resorts. If an employee is cleaning out the cabanas at the hotel and there's an absolutely gigantic hornet's nest hanging that was built, let's say it's the first time they're cleaning it out after the winter, and there's this gigantic hornet's nest that's been built, and the employee is so high that he doesn't see it and he walks into it, kind of like I said, he misses the stop sign or something like that. I could make an argument that impairment may well have led to that employee's injury. If on the other hand, the employee is working at a power press in a factory and a bee somehow flies in there and stings him, yeah, I would not send that employee for a test. But the point really is to make an individualized inquiry into the circumstances of the injury and only send those people for tests where intoxication or being on the influence impairment could have led to that. So if you think about a forklift injury, out of control forklift being driven through a warehouse, the operator rounds the turn coming way too fast. There's an employee who's in the designated walking lane, working on their tablet or their clipboard, doing exactly what they're supposed to be doing. Let's say the driver is not injured, but the pedestrian is, and you send the pedestrian for a drug test. That OSHA would likely have an issue with that, unless there's some indication that the pedestrian may have been impaired and didn't hear the forklift coming around the corner, what have you. So hopefully that gives you some insight into OSHA's approach to this. I think once you kind of understand their motivations and what they're looking for, it enables you to take an approach to effectively determining who should be sent for a test. And this slide just kind of gets into what I've talked about. OSHA is going to be looking at whether you have a reasonable basis to conclude that drug use could have contributed to the injury. Were there other employees? So as I said, this forklift incident, let's say there's a third or four other employees in the area who were also injured. Maybe there was someone who was involved in the pre-shift inspection of the forklift or who had done maintenance on the forklift. If there's some suspicion that the forklift malfunctioned, are you going to test that person? If you have employees working in high hazard work, safety sensitive positions, I think your decision to cast a broader net when you're testing is going to be more easily defensible. And then, this is one area where OSHA, I think, initially signaled that they were trying to get into and evaluate the employer's ability to determine if impairment contributed to the injury, which can, and I believe still remains to be an issue with respect to marijuana, due to, unlike alcohol, it's harder to peg or determine if there's impairment based on a positive test result. As I keep saying whenever I present on this topic, whoever is the first to market with a test that is as conclusive for marijuana as we have for alcohol is probably going to be a very rich person. There are also the OSHA has kind of backtracked over the years since that rule was first released a number of years ago, and now there is greater flexibility to conduct post-accident testing. The one thing I would say under the current administration, there are a number of things that I expect OSHA to take a new look at, and so you had fairly restrictive approach to drug testing during the Obama administration that loosened even during that administration, and I think remained in that way, and perhaps OSHA paid even less attention to it during the Trump administration. We haven't heard any signals yet that they are going to revisit this, but at the same time, we'll continue to watch it, because I would not be surprised if OSHA goes back to taking or more closely scrutinizing employer testing decisions, just as I expect them to take a closer look at record keeping, and possibly expanding the time period in which the agency is going to try to look for violations of the record keeping rule. And because drug testing and record keeping can be intertwined, that's one reason why I would not be surprised to see this focus. So just also talking a little bit about Americans with Disabilities Act, drug use or drug abuse is not considered a disability under the ADA. So there is no restriction imposed by the Americans with Disabilities Act with respect to drug testing. But while I talked about the other types of discrimination at the beginning, race or ethnicity or what have you being one consideration in how you're administering your drug testing program, by and large, disability discrimination claims are the most commonly raised discrimination claim in connection with drug use or drug testing. So as I said before, you need to look at how you implement your policy and how you enforce it. But then the question is, and not only I know we're talking primarily about marijuana, but with respect to painkillers as well, that's an area that can be particularly challenging for employers. If you have an employee who's using a prescription pain medication, and does that impact or impair their ability to perform their job safely? What sort of questions can you ask that person? The ADA places pretty strict limits on employers' ability to ask medical inquiries of applicants. You have a greater flexibility to do so once somebody is employed, but those requests, those inquiries still need to be job related and consistent with some sort of business necessity. I see a lot of times in handbooks and policies that employers sometimes will require, just as a matter of policy, that employees disclose all prescriptions that they're taking as a proactive matter. That is something that the EEOC frowns on as well. So you need to be careful and take a look at if you have any policy like that in your handbook or elsewhere. So, with respect, there are a number of issues that come up with respect to ADA accommodations in the field of drug testing and drug abuse as well. While we're talking about, quite often, I think employers are looking at, do we need to accommodate someone who says they're going for rehab? Do we need to, accommodate somebody who's using medical marijuana? One thing that can be overlooked, and we've seen there've been a number of cases, many of which result in press releases being issued by the EEOC, either when the lawsuit is brought or when the case is settled, surrounding the application process, and whether the employer is obligated to make a reasonable accommodation to the applicant in connection with the drug testing. We've even seen cases, someone who I think the medical term is a shy bladder syndrome, where they're unable to produce a urine sample, or they have a kidney disease or something like that. That is something. You have an applicant who in the course of the pre-screening process, I can't produce a urine sample. You need to take a look at that, find out why that is before you simply bounce them from the process. There are a host of medical conditions and explanations that I think many people are not aware of, and may seem novel or may seem far-fetched. I know there was one case, I think it was someone that had been pulled over for a DUI for being intoxicated, and it turned out that they had some medical condition where their stomach turns food into alcohol, in essence. And so this person blew a breathalyzer result that was above the legal limit, and I believe was arrested for intoxication, when in fact it was simply because of the way their digestive system worked. So it doesn't mean you need to take at face value anything your employees or your applicants say. What I typically encourage employers to do is learn to spot the issues and know when to seek, either when to involve your human resources team and or to reach out to counsel who can advise you on whether this is some issue that you need to accommodate, and if so, how you would go about doing that. We also obviously are seeing an uptick in cases involving the accommodation of medical marijuana. And this, again, because marijuana remains a controlled substance under federal law, the ADA has not been used effectively by employees or the plaintiff's bar to counteract or contradict those types of actions by employers, but we're seeing it brought more under state law. So those states that do have, the majority of the states that have allowed medical marijuana typically then have laws that place or afford some protections to the users of medical marijuana. So just to orient you all on kind of the trends, as I talked about, this momentum that we see building over the last decade or so. We're now up to, I believe it's 34 states, so a pretty significant majority of the states now that have legalized marijuana for certain medical conditions. It includes also the District of Columbia. Then as far as recreational marijuana, we're not yet at half. It's now up to 18 jurisdictions. As you can see here, New Mexico comes online a little bit later this year, as well as Virginia in July. I think what is significant is when you look at this list, it's a lot of the larger states, California, Arizona, Illinois, Michigan, New Mexico, New York, Oregon, Virginia, Washington. So a lot of large states, which means a lot of people. And a significant amount of the population that is able to use marijuana recreationally. And so your law in New Mexico goes, as I said, goes into effect at the end of June. The legal age, I think, like it is here in Illinois, will be 21 to use marijuana recreationally. What's significant and different than a lot of states is that zero tolerance drug policies are still permissible in your state. I'll talk a little bit about zero tolerance and kind of the pros and cons of that. There are a lot of practical considerations that for those clients of ours that have had these policies in place, the impact that they have both from employee relations standpoint and other considerations is something to consider. So fortunately for employers, the New Mexico law does include a number of protections for employers as well. And so you're not restricted in your ability to take adverse employment action against an employee who is impaired by the use of substances at work or during working hours. I think that I call that kind of the no-brainer a component of these laws. I think most states have these. It's just obviously common sense. You even if it's legal, you don't have to allow someone to possess it at work. Certainly don't have to allow somebody to use it while at work. You also have, there's also a carve out that doesn't means that you're not required to commit an act that would cause you to fall out of compliance with federal laws, so such as the DOT or DOD regulations. And as I said before, there's nothing that infringes on your rights to adopt or implement a written zero tolerance policy. And I think that the use of that qualifier written is important. If you're going to have a policy, whether it's zero tolerance or just a general policy with respect to drug testing. I think this goes without saying, but it's just like if you've attended or participated in a seminar, when an employment lawyer has presented, you're almost always hear, document. As I think the OSHA inspectors, many of them that I deal with they like to say things like, if it's not documented, it didn't happen, or trust but verify. And the same thing goes with respect to policies. You want to make sure if you're going to adopt a policy, particularly a zero tolerance policy, that it's in writing, that it's communicated to your employees. Ideally, they acknowledge it, in some form or fashion, either electronically, receipt electronically, or with a written acknowledgement form. So there's no dispute or no debate about their being on notice of what your expectations are and what you're going to be doing to enforce them in the workplace. So, and this gets back to, as I said before, this patchwork of laws. So, if you have operations now in other states, what does that mean from a policy, from a handbook perspective? Those employers or clients of ours that have operations in multiple jurisdictions, you end up either creating a very basic policy in your manual with respect to drug testing, and then have an addendum or multiple addenda at the back that deals with the drug testing rules or regulations that are going to be enforced in the different jurisdictions. You still need to consider compliance with the federal laws such as the ADA and the DOT as well, if you have those types of covered employees. So again, as far as the anti-discrimination statutes that have been, or provisions that have been added in those states that do allow medical marijuana, you can see here a list of the states that have added those, and that includes New Mexico. And so here it's primarily a status. It's a large part of status protection. So as you can see on the second dash in the bottom, that the protections afforded to employees under New Mexico law, you as an employer cannot discriminate against someone because of their status as a registered medical marijuana user. So that means you find out someone has, whether it's a card or whatever it is that gives them that status, you can't simply terminate them because of that. And again, and then also, though, you have to be careful as far as if someone is engaging in or using medical marijuana in a manner that is consistent with the law, that they are then protected from any adverse action as a result of that. Just like you have employer protections with respect to recreational marijuana in New Mexico, there are employee protections with respect to the medical marijuana. Note though, there is, again, as in the case with many drug testing laws, there is a distinction that is drawn and greater flexibility that's afforded to employers for those employees who work in safety sensitive positions. And the law in New Mexico defines a safety sensitive position. As you can see here, it's a position in which performance by a person under the influence of drugs or alcohol would constitute an immediate or direct threat of injury or death to that person or others. So you do have the flexibility, the ability to nonetheless, impose requirements on employees or limit employees who are in safety sensitive positions with respect to the use of medical marijuana. I think we can skip this. And so there's another way that we look at this is this concept of lawful off-duty conduct. And so the question that we ask is, can an employer discipline an employee for off hours or off-site use or influence. So if an employee, for example, has a prescription for medicinal use, I guess I said you can't take adverse action for testing positive. If the employee does not have prescription, however, and is a recreational user, you can, however, can take action. Now, the one thing I think that I assume, it won't take people too much time if they haven't already figured this out. One thing that we've seen and many of our clients have shared with us is, in some cases, it may not be that difficult for certain individuals to find a doctor who will write a prescription for them, or get them that card. And I say that not to implicate the medical community, but more whether it's people that are being dishonest with their doctor. There are, at the same time, there are unethical lawyers. There are probably unethical doctors out there who may be more willing to write prescriptions or give people certain classifications than they should. So I assume what we're going to see more and more of is in states that have legalized recreational and medical marijuana, but don't afford protections to employees for recreational use like they do for medical use. What's going to happen? People are going to come up with conditions that would justify the medical use of marijuana. So you may start to see an uptick in the number of people who are claiming disabilities and such. So I know Jay had asked that I keep my comments to 40 minutes. So I see I'm right at that point. So I'm like Mike, I will stick around for questions if anyone has them, and thank you for having me.
Thank you, Aaron. So there have been some questions in the chat, and I do want to state that, Micah, thank you. You jumped in and you started answering them. So what I may do is skip a couple of those and have you finalize those with those answers if you're okay with that. I would like to start with the first question is, and I'm going to take down whoever asked it in case I don't ask correctly. But Donner asked, how is OSHA going to view if there is an accident related to being impaired and the company has a no tolerance drug policy in place?
I thought I heard someone else. I think I don't believe that having a zero tolerance policy is something. I mean, OSHA doesn't take issue, as far as I've seen, with zero tolerance policies. The inquiry instead is really going to focus on, did the impairment or likely or possibly lead to the accident itself. So what they're really looking at is your decision to test, not necessarily the decision that you take if someone tests positive. Now, I mean, it's a good question, because if I think where you could see the agency take note and maybe conduct a focused inspection would be if there is some evidence that your zero tolerance policy is being applied in a way that people who report an injury or an illness are subjected to more strict or serious discipline than those that do not. Because again, that would be the trigger, if you will, for a suspicion that there's some retaliatory or discriminatory conduct. But if you can show that anybody who's involved in an accident who tests positive is fired, I can't see how OSHA would take issue with that, again, unless they found some evidence that, well, yeah, the 5 people who were injured and whose injuries ended up on the 300 log and tested positive are all fired, but the other individual who was involved in an accident who tested positive but wasn't injured and thus didn't go on the log wasn't fired. That's where you'd likely get in trouble.
Thank you. We had another question come up, and I will get to that. I apologize. I kind of had them written down as they were coming in. Angelique asks, as a federal contractor, can we have an employee that uses cannabis but will not work on the federal site, or will their federal customer jump in and count it towards their whole site, their whole company?
That's a good question. I've not seen the federal government take issue with that. In other words, where they look beyond the people that are assigned to their site. I'm not saying that they couldn't. I've just never seen that happen. So I would think my advice to employers that have multiple sites and multiple obviously employees who are assigned to different sites is obviously you're making sure that the folks working on the federal contract at the federal location are meeting those standards. If you have someone at a non-federal site that's not, I really doubt that they would make an issue of that. It could change with certain industries such as like a defense contractor. That might be an issue, but I don't think that would be a problem.
Thank you. A. Trujillo asked, can I refuse work or employment to someone who identifies as a cannabis smoker?
I think you'd want to again dig into the nature of their use. I mean, if they're saying I'm a recreational user, I think that it's a good question. I mean, I guess if someone is saying I'm going to test positive, I'm going to use it. I think that you would be safe in refusing that employment based on a zero tolerance policy. We have zero tolerance, but again, that's why I think it would be important to adopt that policy, right? I mean, I think anytime you're taking action on anything really, having a policy that sets out the expectations and the results or the implications of violations is always advisable. So if you could respond and say, well, we have a zero tolerance policy, we don't hire people who are recreational cannabis users, I believe, based on the law. And again, some of this obviously when new laws are hitting the books, we have to wait until challenges are brought and court cases kind of filter up through the system to see kind of how the contours of the law are going to be shaped. But based on my reading of the law as drafted before it goes into effect, assuming this is someone as a recreational user, I believe that you would be safe in doing that. Not to punt, but it is something that we lawyers do. If that happens, I would certainly encourage you to if you have legal counsel in New Mexico to contact them to make sure.
I can jump in just a little bit too. I think Aaron's definitely, thank you for speaking to Aaron. I just learned a lot from you. And just on that last question, it'd be like Aaron said, best to consult your legal counsel and to see how any federal funds that come into your business may be affected by hiring a cannabis consumer, right? And then to adjust those policies. Because to have somebody come to you and tell you what they do on their off time or to tell you what medication they're taking, we don't want to encourage a lot of those conversations, but we do because that goes, again, against the Americans with Disabilities Act and all of these things. But the employment protections in House Bill 2, if reviewed again, and look at those against your policies, but then always contact your lawyers. We are hearing word here in New Mexico that some federal funding is being questioned. And so some business owners that are taking in federal funds have already been notified by the federal government and told do not participate in cannabis. Okay. And so those barriers will start to crop up. So like Aaron said, always going back to your legal team so that you can understand how those cross over with your business.
Thank you. Jay Miller, how will OSHA deal with employees entering a residence that is using cannabis? Will OSHA require air monitoring in residents, open areas, etc.?
Let me let me address that one. Okay, I assume they're talking about residential, going to residential construction company or doing some work inside a house. We because it's residential, we're not going to be the exposure would be a limited time. Limited exposure would be secondhand smoke. And so it would be, we wouldn't be doing any kind of air monitoring, anything like that, because we wouldn't have the capability to do that. And the exposure would not be much. They should not have get enough THC in their system to test positive. There shouldn't be any concerns. I guess, Mr. Miller, if you want more edification, pipe in now and let us know. But we would not be really involved in that. If it's residential part, you're going in to do a job, short term, limited exposure, and it's a one shot, one and done kind of thing. And so we don't have the capability to visit all the households in the state of New Mexico to do air monitoring. We have limited capabilities of doing air monitoring with our industrial hygienists.
Okay.
Yeah, I think just to add to that, as Jay said, I mean, I'm flashing back to a current OSHA inspection I have here in Illinois, where there's allegations that air monitoring wasn't done before entry into a grain bin as part of the grain handling standards. So, that the air monitoring is done due to the potential for significant, immediate, potential fatal impact on the employee due to the air conditions inside the bin. I think as Jay's alluding to, you're not going to have that sort of immediate or significant risk to an employee entering a house with where there might be marijuana being used. But I think it does raise an interesting issue from a testing perspective. Is what do you do if someone's employee tests positive and their explanation is, well, you sent me on a job and the folks who lived there were smoking the entire time I was there. And it poses an interesting issue. Nothing I could advise about in advance because it would be so unique, but I think, again, just something one thing I always encourage is to be prepared for the most outlandish, craziest set of facts, because that's typically what happens, or at least those are the ones that typically make it to us, because that's why those are the ones that employers are most concerned about or not sure what to do with. So I could see something like that happening.
Thank you. Wilby had a couple questions, so I'm going to start with the first one, and that's many contractors, fall under DOT regs because of substances they transport, like refrigerant, etc. Does this mean that they need to follow the same regs as CDL or hazmat drivers?
That's probably a little bit beyond what I typically deal with. I think I would say, I guess it depends on, I think there are, assuming that we were talking about vehicles where the driver has to be DOT certified to drive the vehicle, as opposed to other regs that might apply to the cargo or what is being transported. But if assuming that the driver is covered by DOT testing regs and such, I don't think that would change that, but I don't know if anyone else has anything to add to that.
We don't have any. DOT regulations would take precedence. So from Mexico OSHA, we really wouldn't have the authority in a case like that. Well, it's in commerce. If they're moving stuff in commerce and subject to DOT regulations, the DOT regulations would apply and take precedence.
Yeah, it's the same concept that I think we occasionally get the calls where someone sadly is killed in the course of driving a vehicle, for driving their work vehicle. If the accident occurs on a public highway, that it's not going to be reportable to OSHA. However, it doesn't change; it's not recordable on the log, but it would not be something that has to be reported. Now, if it happens in a construction zone, that's another issue. But if it's on the highway, that accident and fatality or hospitalization, amputation would not be something you need to report via call.
So Micah, these are the next couple questions are ones that you had answered in the chat. Are you still on with us?
I am.
Perfect. So Wilby asked, is there recommended training for an employer to be able to assess impairment?
Right now on the civilian side in New Mexico, I don't know of any. I would definitely defer to a lot of other people in this network.
And that's it.
Because I'm stuck in the law enforcement mindset and the training cycle for sure. But I do know that the current contractor for New Mexico Department of Transportation that has the grant for the drug recognition expert program is BRV Consulting. Charlie Files runs that, and he is working on something using us, the DRE instructors throughout the state, to try to get a short, brief program that would be effective for the employers who would want to seek that training out, that would be cost effective for them, time effective, and useful for a day-to-day basis. So hopefully there's more to come on that.
Thank you.
And I would just add, encourage folks to, whatever the resource is, to absolutely train your managers on reasonable suspicion recognition. If you're going to be relying on them to be the ones that identify and send people for testing, you want to make sure that they're trained, that training is documented, you know, and you can show that those decisions were made, you know, for good reason.
This is Ken. I took a class several years ago. The New Mexico contractors used to have a class. It's like a 6-hour class on identifying. In other words, they wanted to have somebody that had some kind of background to identify somebody that was acting suspiciously. They didn't want just anybody walking in and sending people to get tested because of the liability with that. So there used to be a class. I assume there still is.
Thank you. Sorry, some of my chat got lost here, but we do have a question from chat that says, as patients in the current program, normally we have very high nanograms without being impaired. Some of us are always way above the legal limit without being impaired or had smoked within 4 to 5 hours. How will that be dealt with? And Micah, you had jumped in.
Yeah, I think that's probably up my alley just a little bit. That goes right along in the same grain as what I was saying. We have to focus on the impairment. It's funny that he mentions a legal limit. As of right now for driving, there is no legal per se limit for any substance other than alcohol. So, and some of these studies that were also mentioned in the chat feed, I'll just jump and tie those in right now. University of Ohio did one. I believe it was University of Ohio. And Washington State has done one. I believe California is even in the middle of one. NHTSA and the IACP, National Highway Traffic Safety Administration, and the International Association of Chiefs of Police, they've done studies of impaired drivers and stuff like that. There's a lot of that research out there. And what that research is showing is there are some drivers, let's say driver 1 is a recreational user and uses cannabis once or twice a month. They're going to be far more impaired at a much lower nanogram level than, say, somebody who has had their medical card for years and uses a higher dose, but on a very, very regular basis. They're not going to have those signs of impairment as the occasional user will be, but they may be over the 3 nanogram or the 5 nanogram limit that some states have. That's why as law enforcement, we rely very, very heavily on the signs of impairment that we can see, that we can document, that it's just a good foundation for us, as opposed to something else that's a little more arbitrary and has not been studied all the way out, in my opinion, has not been thoroughly studied all the way out. With the opening of the cannabis industry, that is going to be one of the things I'd put definitely in the positive column, is it's going to open up the ability to research so everybody can find out exactly where some of these limits should be set, if they should be set at all.
Thank you.
Now,
So,
Hopefully I made that muddled enough that it passes the lawyer test over there. Aaron, how'd that?
well, muddled is a good term to use if you're talking about, I guess, alcohol, right? With the cocktail, making cocktails and all. But I would just share anecdotally a case that I worked on that I think really illustrates that point about frequent users versus infrequent users. We had a case with an employee, kind of a crazy case of someone who was an on-air TV personality who was on the air drunk, was pulled off the air, came back to meet with the station executive a couple days after the incident, thanked him for being concerned about her. She didn't admit to being intoxicated on the air, and was talking to him in a meeting, walked in and out of the meeting. He smelled alcohol on her, so something that he observed, but noticed no impairment. And so when she went for just a general medical test to kind of evaluate, because she was claiming there was something else that caused her odd actions on air, she blew a 0.32, and she was able to function enough to conduct herself during a meeting. So it kind of can illustrate somewhat. She clearly was a significant and regular consumer of alcohol to be able to do that. So
thank you.
Yeah, and someone like that, in my law enforcement experience, they'll actually be less impaired at that 3.2 and they are at half that at a 1.5 or a 1.6, because they'll start to detox, and that's the way alcohol works. The funny thing is, you mentioned odors. With this cannabis industry opening wide up, edibles, you're not going to have any odor. Vape pens, you're not going to have that odor. They're doing the waxes and the dabbing, not nearly as much odor as smoking the actual flower or bud. So there you go. It's open season on research.
Thank you. I believe there's one more question. I hope I'm not overlooking any of them, and this is from Carrie. Carrie asks, we are a DOT and federal contractor, so the field people definitely fall under safety sensitive functions. But what about hiring for the office staff that do not go out to the field if they have a medical marijuana card, or if they do utilize within the constraints of the new law? Do they have to adhere to the same safety policies that the field people do? I hope I paraphrased that right, Carrie.
I certainly understood the thrust of the question. So I would say, again, I this not being my area of focus, but I would say I would not believe so. I mean, there could still be, just like I think it was the description earlier, that the feds are apparently reaching out to folks in New Mexico, kind of preemptively warning them. I mean, so that suggests to me that there could be some issues, at least, that you'd want to run by counsel who is more experienced in that area. But I would say, I mean, generally DOT regs and testing and compliance obligations are focused obviously on the people that hold those driver's licenses. I would be a little surprised to see that there be any issue with, you have someone who is pushing paper in an office is going to, that would implicate your DOT compliance. But I would still want to look into it with someone who is, holds himself out as a DOT compliance expert.
Thank you. As we,
Excuse me,
yes.
I'm sorry, it's Ken again. I know it's not a protected group, but would we be opening ourselves up to discrimination if we say, okay, well, we test all the field employees, but we don't test office people?
I mean, typically, I mean, discrimination laws protect those who belong to a recognized kind of class. So people, with the age over 40, gender, male or female, you can't discriminate against one or the other. But the law doesn't protect, field versus office personnel in that way. So I think that's pretty low risk. I wouldn't be concerned about that. To be doesn't mean someone won't raise that complaint, but I don't see that as an actionable complaint that they could bring in a court of law or to a state agency.
Well, thank you.
Something that's coming to mind for me on this is that if your business is federally funded overall, then it will have implications on every single employee, whether they're safety sensitive or administrative. And so that's what I want to put on the table, is just to go back to your Drug-Free Workplace Act and to go back to, again, looking at how that will affect. I mean, we can do a lot through company policies and on our end as employers, but when it comes to that federal funding of ODOT employees or ODOT establishments or organizations and how you take in funds, that's going to be your true point of contention on that question, I feel like. But can we, think about safety sensitive versus non-safety sensitive from that company policy perspective and challenge that? Sure. I think it's time to do that. And I hear that that's what's happening in this conversation. And I appreciate that because, not everybody is a safety sensitive worker, but I would hate for any employer to assume that just because somebody's at a desk versus somebody is driving, that they are not going to have repercussions from their Drug-Free Workplace Act and their federal funding. So that's where my heart and my head goes to that piece on there, Ken, and anybody else that's concerned with that.
Thank you. As we are entering into the 10 o'clock hour, we were trying to close up by 10. So I just want to open it up. Does anyone else have any more questions for our guests? I would like to thank our guests for being here today and being a part of our program. Carol, would you like to close us out?
Well, actually, I have one more thing to say before we close out. I would really like to thank Micah, Shannon, and Aaron for their wonderful, wonderful presentations, and Carol and Rhonda for you, your operation of the presentation of the meeting. Thank you all, and everybody has participated and watched this. I'd like to thank everybody. So everybody gives themselves a pat on the back.
Thank you, everyone.
Thank you.
Okay, yeah, I guess
Thank you, Jay.
this meeting, and we appreciate all of you who came. Definitely appreciate the speakers. They did a wonderful job. Jay, Shannon, Micah, and Aaron, you guys are wonderful bringing that information to us. I know you spent some time and energy putting together PowerPoints and getting your presentations ready or whatever, but it was really great. The Construction Safety Coalition does these meetings from time to time, so you may get, any of the attendees may get additional information from us on future meetings. Obviously, if you have a topic or something that you would like us to bring forth, let one of us know. But anyway, thank you guys so much. And Rhonda, thank you for moving this all ahead and keeping it moving as it needed to be. You guys, you're all wonderful. Thank you so much.
Thank you.
Bye.